Hello, this is the Kelso Report Supreme Court Review for the October term 2010, and I'm your host, Clark Kelso. Let's start with cases involving the federal government. The Supreme Court's federal government law cases included important decisions dealing with qualified immunity, the problem of claim splitting between the Court of Federal Claims and the district courts, background checks for government employees, and the Freedom of Information Act. We begin with an important and, for some, controversial decision involving qualified immunity in Ashcroft v. Al-Kid. In Ashcroft v. Al-Kid, you see just how far the court is willing to go to protect government officials charged with exercising broad governmental powers. The issue presented to the court was whether a former attorney general enjoys immunity from suit for damages for allegedly authorizing federal prosecutors to obtain valid material witness warrants for detention of terrorism suspects whom they would otherwise lack probable cause to arrest, when they had no intention of actually calling these suspects as witnesses in any trial. In other words, the material witness warrant was simply a pretext for detention of the terrorism suspect. Under the court's qualified immunity jurisprudence, federal and state officials are shielded from money damages unless a plaintiff pleads facts showing, number one, that the official violated a statutory or constitutional right, and number two, that the right was clearly established at the time of the challenged conduct. The court has made it clear that the analysis under this two-part test can proceed in either order, so you can analyze the clearly established part of the test first. This flexibility makes it possible to decide that a right was not clearly established without actually having to hold that the right exists, since a court may reason that even if it existed, it certainly was not clearly established whenever the challenged conduct occurred. Well, the Ninth Circuit in this case found that Ashcroft had violated a constitutional right, since the Fourth Amendment allegedly prohibited using a material witness warrant simply to detain a person as a suspected criminal, and that the particular right was clearly established at the time of the challenged conduct. The Supreme Court disagreed with both conclusions. On the first issue, the court held that the constitutionality of a material witness warrant must be determined solely on an objective basis, and that the subjective motivation of the officer, that is, whether the warrant was really a pretext simply to hold the person, was irrelevant. On an objective basis, given the information presented to the magistrate who approved the warrant, there clearly was enough to hold the plaintiff. On the second issue, the court noted that not a single judicial opinion had held that pretext could render an objectively reasonable arrest pursuant to a material witness warrant unconstitutional. In these circumstances, it is pretty hard to say that the right was clearly established. Note how these rules protect high government official decision-making. If the official's legal counsel can fashion an argument that the proposed conduct is legal so that it doesn't violate a clearly established right, the government official can authorize the action without fear of liability for damages, even if the proposed conduct might actually be determined to be illegal if the merits were ever reached. But with qualified immunity in place, it is very hard to get to the merits. Well, our next case, United States v. Tohono O'odham Nation, involves the proper interpretation of one of the most confusing statutes dealing with the jurisdiction of the Court of Federal Claims, and the problem of claim splitting between that court and the district courts. Section 1500 of Title 28 bars Court of Federal Claims jurisdiction over a claim if the plaintiff has another suit for or in respect to that claim pending against the United States or its agents in another court. The court's decision in Tohono O'odham Nation goes a long way towards clarifying the statute's interpretation, although it leaves litigants with a very difficult choice. The plaintiff had filed suit in federal district court against federal officials who managed tribal assets held in trust for the federal government, alleging violations of fiduciary duty and requesting equitable relief. The next day, the plaintiff filed an action against the United States in the Court of Federal Claims, alleging almost identical violations and requesting money damages. In a 5-3 decision with the majority opinion by Justice Kennedy, the court held that the statute barred the subsequently filed action in the Court of Federal Claims, because the action was based on substantially the same operative facts as the district court suit. It didn't matter that the relief sought in the two actions was entirely different: equitable relief in the district court and damages in the Court of Federal Claims. According to the Supreme Court, the statutory language "claim for or in respect to which" referred simply to whether the two actions were based on substantially the same operative facts. The court's holding leaves a potential remedial gap for plaintiffs, since the Court of Federal Claims has no general equitable powers, and many claims for damages against the government can be brought only in the Court of Federal Claims. So plaintiffs will sometimes be faced with a tough choice: forego equitable relief to pursue a damage claim in the Court of Federal Claims, or hold off on the damages claim to pursue equitable relief in a district court, and after that action is concluded, only then move forward with the damages claim in the Court of Federal Claims, assuming statute of limitations is not already run and there is no preclusive effect of the first lawsuit. So it puts the plaintiff to some fairly difficult choices. We now turn to the constitutionality of certain inquiries that are a standard part of background checks for federal employees and contractors. The issue arose in National Aeronautics and Space Administration versus Nelson. The allegedly offensive questions were as follows. First, as a follow-up to the question of whether the employee had ever used, possessed, supplied, or manufactured illegal drugs in the last year, the employee must provide certain details, including any treatment or counseling received. Second, a form sent to references has a series of open-ended questions asking whether the reference has any reason to question the employee's honesty or trustworthiness, whether the reference knows of any adverse information concerning the employee's violations of the law, financial integrity, abuse of alcohol and/or drugs, and other matters. Pursuant to a change in policy after the 9/11 attacks, the background check forms were made applicable to employees of government contractors who had long-term access to federal facilities. 28 government contractor employees at the Jet Propulsion Laboratory in Pasadena sued to block portions of the background check based on an asserted constitutional right to informational privacy. The Ninth Circuit held that a preliminary injunction should be granted because the treatment or counseling questions and the open-ended questions to references were likely to be held unconstitutional as an invasion of privacy. The Supreme Court unanimously reversed, with an opinion by Justice Alito over 6 justices and concurring opinions by Scalia and Thomas. The majority assumed, without deciding and without any real discussion, that the Constitution might protect some type of informational privacy, including an interest in avoiding disclosure of personal matters. But even assuming such an interest, the majority held that the federal government as an employer has an interest in learning whether employees who were going to work at the Jet Propulsion Laboratory had drug or alcohol issues, and if they did, whether they had sought treatment and whether such treatment was successful. Similarly, the open-ended questions on the references were upheld as legitimate efforts to learn about prospective employees. The majority noted that all of this private information was protected from further disclosure by the government, so the collection of the information was not likely to result in public or other disclosures unrelated to the government's interest as employer. Well, we close our federal cases with 2 cases involving the Freedom of Information Act. The first case, Miller v. Department of the Navy, deals with a proper interpretation of the personnel records exception to the Freedom of Information Act. Now, as we know, FOIA requires agencies to make records available to the public on request, subject to some exceptions. One of the exceptions is for material related solely to the internal personnel rules and practices of an agency. In Milner v. Department of the Navy, the court faced a FOIA request seeking explosive safety quantity distance information regarding the risk posed by storage of weapons, ammunition, and explosives at a particular Navy base in Puget Sound. The department refused to disclose, citing, among other things, Exemption 2, the personnel exemption, which had been interpreted by several lower courts as exempting from disclosure predominantly internal information where disclosure would risk circumvention of the law. As interpreted, Exemption 2's scope went far beyond the language of the exemption, which is limited to material, quote, related solely to the internal personnel rules and practices of an agency, close quote. The genesis of the broad interpretation goes back to a 1976 Supreme Court decision, Department of Air Force versus Rose, where the court had also rejected a broad interpretation of the exemption, but added a reservation that the court's holding applied at least where the situation is not one where disclosure may risk circumvention of agency regulation. Over the years, the courts of appeal took this language and ran with it. Well, the long run is over. In yesterday's decision, the court stuck to the language of Exemption 2 and held that its scope really is limited to personnel rules and practices. That is, human relations issues. Our second case, Federal Communications Commission versus AT&T, involves the interpretation of Exemption 7C, dealing with the personal privacy exemption for law enforcement records. AT&T voluntarily reported to the Federal Communications Commission that it may have overcharged the government for costs in the FCC's E-rate program, which enhanced access for schools and libraries to advanced telecom services. AT&T subsequently cooperated with an investigation by the FCC by turning over documents, emails, and invoices, which included pricing and billing information, names and job descriptions of employees involved, and AT&T's internal assessment of whether any of those employees had violated AT&T's code of conduct. A competitor later sought all pleadings and correspondence held by the FCC regarding the AT&T investigation. The FCC concluded that some of the information provided by AT&T was protected under FOIA as trade secrets and commercial or financial information. The FCC also withheld other information pursuant to the FOIA exemption for records or information compiled for law enforcement purposes that could reasonably be expected to constitute an unwarranted invasion of personal privacy. The FCC applied this exemption to protect individuals identified in the AT&T documents who have privacy rights warranting protection. However, the FCC refused to apply the exemption broadly to protect AT&T's own corporate interests, reasoning that businesses do not possess personal privacy interests. The Third Circuit Court of Appeals found in favor of AT&T. The court reasoned that the root word in personal is person, and person was defined by the statute to include corporations. Therefore, when Congress used the phrase personal privacy, it must have intended to recognize that corporations have privacy interests. The court explained that, quote, it would be very odd indeed for an adjectival form of a defined term not to refer back to that defined term, close quote. Well, in FCC versus AT&T, the Supreme Court reversed unanimously with an opinion by Chief Justice Roberts. What was actually odd here was not that person and personal might refer to different things, but that the Third Circuit permitted itself to be drawn into a rigid grammatical imperative in interpreting the statutory language. FOIA defines the word person to include corporations, and that is, of course, the typical legal definition of the word. But FOIA does not define the word personal, and absent a special definition, courts ordinarily will give such a word its ordinary meaning. The ordinary meaning of personal refers to individuals, not to organizations, corporations, or other artificial entities. That is probably why, as a more general matter, courts have not recognized that corporations have privacy interests. As the Restatement Second of Torts explains rather succinctly, a corporation, partnership, or unincorporated association has no personal right of privacy. Well, that's it for our review of federal government law cases. In our next segment, we'll take a look at state and local government law. You can click on the state and local government law link in the Supreme Court Review table of contents.